The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. We are here this morning for three different cases to be submitted. The first two will be by oral argument. The case of State versus George Davis is submitted at this time without oral argument. We will now move to the case of In the Interest of T.F. And I believe the first person to go will be Ms. Zendeias. Am I pronouncing it correctly? Zendeias. Okay, thank you.
May it please the court, counsel. My name is Alexis Zendejas, attorney for Appellant-Intervenor, the Omaha Tribe of Nebraska. The issues presented today speak to a larger attack on the breakdown of the protections of the federal and state Indian Child Welfare Act, and thereby on Indian children and families. Through the Indian Child Welfare Act, the state and federal governments have a compelling interest to uphold tribal survival and sovereignty. The appellate court erred in affirming the district court's decision to deny the motion to transfer and subsequent decision to terminate parental rights for 5 reasons. 1, that the guardian ad litem should not have been able to object to the transfer. 2, the motion to transfer was denied based on the district court's misapplication of the best interest of the child standard and impermissible factors. 3, the state did not meet their burden to provide active efforts because the tribe was only contacted once through their attorney. 4, the state did not meet their burden of proof to terminate parental rights. And 5, only one qualified expert witness testified when more than one is required by statute from the plain and unambiguous meaning of the text. The Omaha Tribe asked this court to vacate the termination of parental rights order and remand this case with instructions to transfer the case to Omaha Tribal Court.
JL, do we have to overrule that I'm sorry if you can understand me, what you make of JL, the case, and will it be necessary for us to overrule, or at least say JL is not good law to be with you on the jurisdictional issue?
Yes, Your Honor, in part. I believe that in re JL was correct when it said that the best interest of the child standard is not the standard to determine whether or not to transfer. But in regards to the second analysis, the appellate court's decision in re JL was erroneous because it determined that the Iowa ICWA was unconstitutional and allowed for a guardian ad litem to transfer. In re JL discussed the strict constructionist, textualist argument that ICWA should be.
I'm going to be with you for now, at least, on the statutory argument. Let's just put that aside. But the constitutional argument is what strikes me as the guts of JL. And there's a procedural aspect to it, and then a substantive due process aspect. And to paraphrase JL, it basically says, well, when there's a transfer motion pending, the court can consider the best interest of the child because failure to do so would violate substantive due process. That's how I read it, at least. And tell me why that's wrong.
Well, yes, Your Honor. The tribe's assertion is that they misapplied that due process issue because there's no protected interest at stake in a motion to transfer hearing with familial associations. The legislative history indicates that the transfer provision of ICWA is intended to protect the rights of the child as an enrolled or eligible member of an Indian tribe. And that even if there is a protected interest at stake, and I believe that the familial association's interest may not be the correct interest. In re JL, they also said that the compelling interest of the state was the tribe's right to sovereignty. And in re JL mentions this analysis for determining whether due process was violated. And one prong of that analysis is the risk of erroneous deprivation of the interest by current procedures used. And by not transferring the case, this court is more at risk of depriving Indian children of that familial association by terminating parental rights. Authorizing a guardian ad litem to object to tribal court jurisdiction doesn't advance the compelling interest that the state recognized in Ray JL.
JL question, does it matter at all that the statutory provisions provide that the child is a party to the proceedings under 232-89 and 113? If that's correct, shouldn't the child have a statutory right to make procedural motions like objecting to the transfer of jurisdiction?
No, Your Honor, because the statute doesn't read like that for motions to transfer. The motion to transfer statute says that only the parent or the Indian tribe can object to that. And ICWA must be construed strictly in its text. And
The middle ground would be, well, the child can object to transfer based on forum known convenience grounds. For example, if the transfer was going to be to someplace in Alaska or Hawaii or something like that, that might be very remote. But perhaps the child cannot raise the best interest of the child as part of the transfer. In other words, the transfer provision is only related to what I'll call forum known convenience type issues, and the child can raise those just like everybody else. Isn't that a plausible resolution?
yes, Your Honor, in following with the statute, in Ray NV, or in the interest of NV, that's what this court decided. And even still, if the court decided to provide this judicial remedy to a legislative issue or a statutory problem, the state still didn't meet their burden of clear and convincing evidence that good cause exists to transfer by not transferring because they used impermissible factors to deny the transfer. And even further, they didn't meet their...
Up on that, Ms. Zendeias. So if we conclude that under that federal regulation that lists certain factors that are not to be considered, the juvenile court considered some impermissible factors, do we then decide the motion to transfer ourselves, or do we send it to the juvenile court to now consider to make a determination using only permissible factors? What's the remedy?
Your Honor, we're asking this court to vacate that termination of parental rights and ask that the case be remanded, or to vacate termination of parental rights with instructions to send it to tribal court based off of the analysis.
Own weighing of all, our own determination whether transfer was appropriate? Is that what we're supposed to do?
Yes, Your Honor. Because the appellate court, the impermissible factors here were couched in a best interest of the child analysis, and that's not the standard. The appellate court determined in Ray JL in that first analysis, but also that this court determined that good cause, not best interest of the child, was the standard in the interest of NB.
There'd be, I'm sorry, this is, on remand, maybe there'd be an argument that the tribal courts aren't open or aren't functioning. And using a forum known convenience analysis, taking a narrow view of the statute, which we can debate later, but assuming a narrow view of the statute, there might be an argument left that says, well, transfer should be denied on the narrow grounds. No?
I don't believe so, Your Honor, because in the good cause analysis said that the state shall transfer the case to tribal court unless the tribe declines the transfer of jurisdiction, and that didn't happen here. The tribe does have subject matter jurisdiction, which is a second prong. And as for the undue hardship or the forum non-convenes argument,
Good cause in the context of a forum known convenience type jurisdictional statute might include, if you could show this, that the tribal courts were not available for some reason. They were closed, or the tribal courts were located in some way that the evidence just couldn't be developed. or the tribal courts lack subpoena power maybe or something, you know. I'm not sure, I'm grappling with the notion of, even if you're correct on the narrowness of the transfer provision, shouldn't there be an opportunity to show good cause if they can, if the state can, on the narrower ground?
No, sorry, I'm going to answer that with a no, because the tribe was available for the termination of parental rights hearing and the transfer hearing all via Zoom, and everything happened electronically, and as for the termination of parental rights, the burden or the active efforts was not complied with in as it goes for 232B.5 sub 19, where the state was required to work with the Indian child's tribe.
About, you mentioned the transfer hearing was conducted by Zoom, and I believe that was in, I don't know when it exactly was, but the tribe moved to transfer in February of 2020, is that right? Does that sound about right? And the juvenile court did not deny the motion until September 2020. And what troubles me is, it seems to me when there's this kind of a motion, it should be decided immediately so that things don't keep happening with this family and other developments don't keep happening in the case. It should be moved immediately to the tribal court if it's going to be moved there. So what effort was made to kind of expedite the process? Do you know?
I am unaware of, Your Honor. I do know that the transfer hearing happened in, I believe, June and July of that same year, of 2020.
That we were in the midst of the beginning of COVID, but all of this was happening by Zoom anyway. Am I correct?
Are the tribal courts open now if we were to reverse and order a transfer?
They're open, and they were open for the duration of this case as well. Our tribal court is equipped with Zoom technology, and we have a tribal judge that Skypes in from Oklahoma sometimes.
Made a finding of advanced stage. Can you address that? What's your position on whether or not the proceeding was at an advanced stage?
I believe that that's part of the impermissible factors that are not permissible pursuant to 25 CFR 23.118C, where the advanced stage of the proceeding should not impact the motion to transfer hearing.
Whether good cause exists, the court must not consider, so you cannot consider sub 1, advanced stage if the Indian child's parent, custodian, or tribe did not receive notice. That's not the case, is it?
No, Your Honor. But even still, the advanced stage of the proceedings should not impact the decision here, because
that the court was allowed to talk about advanced stage. Tell me why you think it was not at an advanced stage.
Because the Indian Child Welfare Act's purpose is to protect the tribe and the child, the Indian child as pursuant and defined by the Indian Child Welfare Act. And at any stage of the proceedings, the tribe can make that motion to transfer pursuant to the purposes of the Indian Child Welfare Act, where we are looking at the rights of the Indian child as an enrolled citizen or eligible for enrolled citizen of a tribe. And those interests should be protected at any stage of the proceeding, regardless of how far along the district court believes our motion was submitted.
A little bit about the relationship between the federal regulations and Iowa ICWA. And specifically, as I understand it, the grounds for denial of the motion to transfer are a showing of good cause under 232B5 sub 13. Is that right? So is it possible that the Iowa ICWA is somewhat narrower or more protective of the tribe's rights maybe than in other jurisdictions or the federal regulations. I'm not sure how those federal regulations impact our interpretation of this statute.
Regulations, well, especially as in compared to in Ray JL or any other ICWA case, as they were mentioned before, is that they have been updated to be included, to include these impermissible factors. And they still need to be upheld in state court. And I don't believe that the district court did that here.
Differently. So under 232B, sub 5, sub 13, there are 4 grounds for denying a motion to transfer, 4 grounds for good cause, correct? And best interest and advanced stage are not listed as factors under our state statute, right? So is it even relevant what the federal regs say if our statute doesn't include them?
Yes, Your Honor, the federal regulations are still relevant. And I just pray that this court vacate the termination of parental rights and remand this case to the tribal court. Thank you.
Mr. Causey? Representing the father, correct?
Chief Justice Christensen, other members of the Iowa Supreme Court, Counsel. I'm also honored to have many members of the Omaha tribe here today. May it please the court. I was going to start off by arguing my late appeal, but it doesn't sound like that's the issue. I think that what we're talking about here is sort of it's a mix-up of placement versus jurisdiction. The argument of good interest of the child, best interest of the child, is really, in my opinion, a wolf in sheep's clothing. It is arguing these impermissible grounds by just saying it's in the best interest of the child. The guardian ad litem even admitted this at trial by saying that that they were worried that the children were doing so well in this foster family, and that is by inference saying that somehow the tribe would have moved the children later, even though there was no such evidence at our trial whatsoever that these children would be moved. In fact, Messiah Harlan of the Omaha tribe stated that they had no plans to move these children. And there was no evidence that these children's due process would be in some sort of jeopardy in the tribal court. Again, to say that that is the case or to even infer it is to coming back to the same reason that ICWA was implemented in the very first place. It's this sort of negative inference that the tribe cannot take care of their children for some reason. You know, if the tribe takes over the case, the child still gets a guardian ad litem. They still have due process. They still can object to placement changes at that point. And here, again, it's sort of best interest of the child is couched, or these impermissible reasons are couched within this argument of the best interest of the child. And frankly, the Court of Appeals cites this Chester County Department of Social Services versus Coleman, which I believe technically agrees with this position. It quotes that the legislative history of the federal ICWA states that the use of the term good cause was designated to provide state courts with flexibility in determining the disposition of a placement proceeding involving an Indian child. And again, we're not talking about placement. We're talking about a transfer of jurisdiction. And so again, to infer that somehow the tribal court is not in a good position to determine what is in the best interest of these Indian children, or to say that for some reason these children's due process will be in jeopardy, I believe, again, is really going back to the whole heart of ICWA back in the 70s when Chief Isaac was from the band of Choctaws out of Mississippi, was saying that the problem here is that these individuals in state governments and state courts are making decisions that really affect the future of these tribes when they have no intelligent basis to make these decisions, and sometimes are almost contemptful of the way of the Native American courts.
Let's talk about JL again, and I'll repeat some of the same questions I had of other counsel. JL, it seems to me, says that there's a substantive due process right because of the familial relationships involved to challenge a transfer order. Now, you can question my interpretation of the case, but that's what I think it says. Correct me if I'm wrong, and if I'm not wrong, tell me why JL is incorrect. Substantive due process, the child is entitled to have the best interest considered as part of a transfer motion. And if, to the extent the statutes are narrower, they fail the constitutional test.
But again, I think that it is wrong, and I've already written that I would ask that it be overturned, because what is happening is, again, it's a mixture of what they're concerned with as far as placement versus what I believe is the transfer of jurisdiction. And this idea that if you read all of the ICWA codes, the federal and the Iowa ICWA, and I think Justice McDonald had asked something about whether or not the Iowa ICWA gives them more protection. In fact, it was written, I wrote it in my legislative history, that it gave more protection to the tribe and the tribal children. And again, this familial association is tribe-centric. And I think it was Justice Wiggins that wrote about this in NRA NV, that the best interest of the child, and again, in that case, it was the state arguing the same thing the guardian ad litem is arguing. It's not a difference in argument, it's a difference in the person arguing it. But again, that the best interests of the child are by placing him or her in a home that will preserve the unique values of the child's tribal culture and assist the child in establishing relationships with the tribe. And again, if we're talking about the procedural due process, I don't think that the child needs to be objecting to a change of jurisdiction versus, yes, potentially in the future at a tribal court, if there is a change in placement that's going to affect some sort of familial association, if we agree that that is a liberty interest that should be protected by due process, they can make that argument in the tribal jurisdiction, because there again, we're going back to the same negative inferences we're not allowed to go back to, and that is that somehow a tribal judge will not think of the best interest of the child, and they will somehow move that child to an unsafe place. And again, if the court is not inclined, which I know that sometimes we don't like to touch on these constitutional issues, in this particular case, there are no facts that were ever presented that would show. NRA JL, I believe, is the case where the court knew, the juvenile court knew, that two out of the three children were going to be transferred to a alleged abusive grandfather, if I'm remembering correctly. That was something that the court knew at the time. Here, no evidence was presented that the children were in any kind of danger. And again, the familial association.
There was evidence that Dad had been involved in a number of abusive actions, and indeed has a criminal record, as you know, related to domestic abuse. Isn't that something that the court ought to take into account?
We're talking about my client, correct, Your Honor? Okay. Justice Appel, I don't think so. I think, again, we are confusing the ideas that the Omaha tribe does not believe in termination of parental rights. And so the easy argument that I believe was in our case, even though nobody's explicitly said it, was that we have to keep this case in state court because we know that under subsection H, he's in prison. He can't have the kids at the time of the termination. His rights are going to be terminated. That's in the best interest of the children because he's a dangerous individual and mom has mental health and drug issues, right? Well, the problem here is that then what we're doing is again, just sort of molding our arguments but using impermissible reasons for not transferring it. Just because the Omaha tribe does not believe in termination of parental rights doesn't mean that that decision is somehow wrong, and therefore the state court's decision to terminate rights is right. I think that here, what we have to consider is the reason ICWA was written is because the tribe needed to take care of their children. And any kind of inference that they were incapable of taking care of their own children was written out of the law. And the reason that was done is because they weren't going to allow this in the future. It's as if they had a premonition that these types of instances would occur, that somebody would argue that the social services in the tribe were not good enough for these children, and therefore their best interest would be served staying under the state's umbrella of jurisdiction, or that the tribal courts were not in a position to handle this case, and therefore they should stay in the state, or that somehow the tribal court might make the decision to move placement or something, and that would not be in the best interest. And so they literally codified all of these to eliminate them as reasons that we're going to be able to move or to deny a transfer of jurisdiction.
Yeah, I mean, I think people agree with and understand the purpose of ICWA, and it's a valid purpose. The concern I have is sort of the stage of the proceedings here. Are we certain that a denial of transfer, for one thing, that's not appealable? It seems odd to me that the court can deny the transfer in September of 2020, then things go on, and there's a termination hearing, and here it is December of 2021, and we're arguing about a transfer that was denied over a year ago. That isn't in the best interest of anybody, the child, the foster parents, the kid, your client. I mean, is that certain that that's not an appealable order?
Obviously, that was the AG's argument, and when I read that, as an individual who has very limited experience in ICWA, I thought that seemed like a practical argument, that at the moment that the transfer is denied, that one would want to appeal that as a final order, because obviously, as you've just stated, we're now down the road a long ways, and the kids have been living, I'm assuming, at the same foster family and growing accustomed to their culture and things of that nature. Clearly, at the time that we dealt with this issue, I believe the ruling was in September of 2020, the case law dictated that it was interlocutory and therefore you could raise it later. I think the argument that it might be more efficient to call it a final order, again, as somebody who has done little of the ICWA work except for this case, I thought it was a good idea, but I've been informed by Ms. Zendeias that honestly what happens a lot in these cases is that the parent under the code may object to it, and therefore the transfer can't happen, because that's one of the reasons that you would deny transfer is if a parent objects. But then later on down the road, hoping that they would have done the case plan in state court, get their children back, have the case, close in a positive way, that doesn't happen. And then later, when the tribe wants to transfer again, probably in some sort of agreement with the parent's attorney, they file it again, and therefore the parent has another chance to not object. And then I think the unfettered transfer needs to happen at any time. I also think there's something here that probably doesn't show up in the record. Some tribes are really living high on the hog, and some of them are very poor. And what happens is a lot of times I think they don't get in the case for a while because of the fact, and they don't ask for these transfers because frankly they're also waiting and hoping that the parents, for lack of a better term, get their act together and get their kids back and have the case closed in a positive way. And again, my feeling from where I'm coming from is that it's not the state's place or even a state's court to sort of interfere with the sovereignty of the tribal jurisdiction. And we're talking about two sovereign nations here, and if the tribe wants their children, whenever that happens, they get them, is the way I read the law.
Interpretation of whether or not that this was at an advanced stage of the proceeding when the request was made.
Chief Justice, I think, again, that's an impermissible ground because the legislators that wrote these laws could see this coming. Again, I'm not sure that there's an advanced stage argument other than to say that the advanced stage makes it so that this is, again, not in the best interest, and somehow the tribal court couldn't step into the shoes of the state court and provide these children with due process and provide them with social services. Again, I think what Judge Vithis-Warren was saying is that a lot of these arguments are the same, they just sort of show up in a different way. And I think that we touched on the forum nonconvenience as well. Again, that is listed in there, and I think that is a viable argument. And with what we're asking is that that the transfer should have happened. That none of this other stuff matters if the transfer happens. The active efforts argument, the notices of appeal. It was asked earlier about whether or not you should make the decision. I think Justice Mansfield asked if this court should make the decision and transfer them. I don't think it matters. I mean, because if you return it to the state court, then the only grounds they can raise to argue deny of transfer fall apart based under the facts that we have. If I can, I would, I'm sorry.
The motion to transfer made within 10 days of the change in the goal to permanency in an effort to terminate?
I'll do is I'll base it based on my knowledge. I'm not sure if y'all are aware, but the previous counsel that represented the father withdrew in May of 2020, and I got on the case then, and that's why his petition is not filed until June of 2020. I believe that the TPR petition was filed in January of 2020, and that's when they filed the motion to transfer. And again, I'm guessing here. I'm thinking that what the tribe does is they hope that these parents will, because these parents are not living on the reservation. I realize that's not a reason that we don't transfer, but I think in a logistical, practical sense that matters to the actual tribe, that if the parents in their own community where they've been living with these children can actually get their act together and close the case, then why transfer it to the jurisdiction of the tribe anyway? If I was running the tribe, I might make a different decision. I might say transfer them immediately and let's get over here. But again, you know, the conversations that we have as attorneys with our parents at one particular moment is, and I'll just be honest, is frankly, you better get it to tribal court because in state court, you're dead to rights under certain subsections like H, where if they're not able to take the child at that particular moment, then they're done. Thank you so much, Justices.
Ms. Triick and Ms. Siebrecht are going to share their time, so we'll leave it up to you two to divide that up. Question right out of the chute. What'd they do wrong? Seems to me like the tribe did everything juvenile court would want. They were there. They filed an ICWA expert witness affidavit the same day the parents' consent to temporary removal was filed, which is before cases even started. And they said out loud, we don't believe in TPR. And then my review of the file, removal, adjudication, disposition, modification, placement, review, and permanency, every step of the way, the tribe was there. Correct me if I'm wrong.
I think you're correct. I think they were there, but I don't think they were actually involved. I think they witnessed what was happening, but did very little other than witnessing what was happening in court. I believe if we don't give children a voice at every step, at every stage in these child in need of assistance proceedings, then the Indian children actually have less rights than non-Indian children. If we were to consider transferring a child in need of assistance case to a different state, the child has a voice in that decision. If we were to even transfer concurrent jurisdiction, give it to the district court to make a decision regarding placement of children, we give the children a voice. So why aren't we doing this in an ICWA case?
That an Indian tribe sitting there participating in hearings just because they may not disagree with what the court says, I mean, maybe there's not a reason at that point to complain. Isn't their silence also an okay with what's going on thus far?
It is. It wasn't okay up until the time that they requested transfer. At that point in time, which was very late in the proceedings,
Just very late. There's something significant that happened. You guys said over TPR. And from the very first day, the tribe said, don't go to TPR. I mean, we don't agree with TPR. It's not advanced if there's a significant stage, do you think?
that the tribe was also aware that if these parents didn't get their acts together, if they weren't able to keep these children safely in their care, that would end up being the permanency goal, would be termination. And so they should have requested that transfer much earlier.
Some federal guidelines that talk about what advanced stage of the proceeding means, and they say the proceeding is not the whole China or whatever, it's the specific, it would be the termination. And they they didn't move to transfer at a late stage of the termination. They moved to transfer right at the beginning. I'm looking at a South Dakota case that was decided earlier this year that relied on federal guidance. Isn't that what the federal guidance is?
But again, in this case, it had gone on for over a year, I believe. I would ask for some grace as I am brand new to this case within the last 2 weeks. But I believe it was over a year before the transfer was requested in this case. And yes, it was at the time that the tribe became aware that the state was serious and they intended to terminate parental rights. But we have to look at the best interest of the children. We have to. That is our overriding priority in all of our.
We do if we have jurisdiction, but if the case is going to be transferred, and that's the determination, I think, doesn't the father's attorney raise a valid point? I mean, if you're the tribe, why would you expend resources and get involved and file a motion to transfer in court if it's not clear that anything in particular is going to happen to this child? It's when the termination is sort of in the offing. At that point, you would want the case to be transferred. What's wrong with that as a governing principle?
This case specifically, the facts of this case, it was evident what was going to happen. Repeatedly, these children were removed from the mother's care, placed somewhere else, returned back to the mother, and again removed. I think it was pretty clear what was going to happen.
DHS, though, those weren't the tribe's actions. DHS made those efforts. They were the ones that were trying unsuccessfully to do something. The tribe, you can't say that same thing about the tribe's choices in that respect, can you?
And I'm not saying that was the tribe's choice, but the tribe could see, because the tribe was attending all of the hearings. The tribe was aware what was happening with these children. It was apparent that these parents weren't taking the necessary steps to make sure that the children could be returned permanently to their care.
I mean, let's just, I know that the ICWA statute defines the Indian child's family or extended family member as what I consider to be typical, as in my own life, for example. I am not a member of any tribe, of course, but parent, sibling, grandparent, aunt or uncle, cousin. That's really normal for the juvenile court setting. And then it takes a really hard left turn. Clan member or band member. That's part of their world. That is their family, unlike me or anyone else. So when I was in the courtroom and had Aunt Sally sitting out there being quiet as a church mouse, and then all of a sudden we say TPR, all of a sudden she raises her hand and says, okay, I'll think about the kids with me. But she's hopeful. She's hopeful her niece will get her act together and gives her that time. How is that any different than a tribe when they finally say, doggone it, they haven't done what they're supposed to do, we need to step in?
Different, because at least in my experience, when Aunt Sally waits until the last minute, it's too late for her as well. Because we are
involved in the proceedings, is literally on every pleading, at every hearing. I don't think a judge would find that she hadn't been involved. Wasn't she in the wings waiting?
If she had intervened in the case, then she would have been involved. I think if she was just there witnessing, no, it would be too late for her.
Well, the tribe in this case, whether you want to call it intervention, they're asking for a transfer of jurisdiction. They were involved at every stage of the proceeding, call it intervening or not. Isn't that a little different?
But I still believe that we need to look at what is in the best interest of the child.
Tribal court is competent to determine what's in the best interest of the child? Then why don't we leave that decision to the tribal court? You keep saying that somebody has to make a best interest determination. Our question is jurisdictional. If you think the tribal court can make the same decision as a state court, then why not transfer it?
And I think we look at the late stage of the proceedings. I think that, at least from the evidence that
We have to look at the best interest of the child. If you think the tribal court can make that same determination a state court can, then why is that best interest analysis relevant to the jurisdictional issue?
the tribal court, the tribe, didn't even know anything about these children. The expert witness wasn't able to testify as,
Jurisdiction, I mean, we assume that they're going to have a process and a procedure in place where they can obtain information about this family and these children. Why can't the tribe make the best interest determination? And if they can, why should we be considering it at this stage?
Can make that determination, but then we are delaying the permanency for these children. I think our juvenile court in Polk County, in this case, was better situated to make those decisions.
The premise of the argument that you think the state courts are just going to do a better, more expedient job than the tribal court, therefore we should just retain jurisdiction.
No. And I apologize, I have to defer to the state for her argument. Thank you.
May it please the court. This case presents this court an opportunity that doesn't come around often to establish some Supreme Court binding precedent on some really important ICWA-related issues. The first of which I want to make sure I have time to address, is this question of finality and appealability of a denial of transfer order. In 2016 in ED, an unpublished decision of the Court of Appeals was issued which found this kind of an order to be an interlocutory order. And the court's reasoning on that was simply that it did not dispose of all the issues in the case. But this is a China case, and that can't be the entirety of our inquiry as to whether an order is final, or we would not have final orders in China cases until you got to case closure or perhaps permanency.
Order, right? And this is kind of like that, right?
Also kind of like a denial of intervention by a proposed intervenor. I think what we need to ask in China cases is whether we have a definitive final answer on the legal question that's before the court, or whether or not we have some sort of temporary decision that's going to be followed by a subsequent final decision that sort of disposes of that set of legal issues.
Because, I was on the Court of Appeals for a while, and I found this whole idea of what's an appealable order under 232 to be a total minefield for the judges, for the practitioners, for everybody. And it would seem to me very unfair at this point in time to say, well, you should have appealed back in September 2020.
That there's sort of two ways to look at that. So first of all, I would say that we have in the ICWA realm a lot of published Court of Appeals cases, and I think it's noteworthy that this Court of Appeals case, which is the only one that makes this finding, is an unpublished case. And so I think that it would be incorrect to say that everybody knew for sure that there was established case law on this question. The second thing I would say is that I would encourage this court, even if you were to find that you were going to allow this appeal to proceed, to make clear that in the future that these orders should be considered final appealable orders. I certainly, as a practitioner, appreciate that these issues are very complicated in China cases, and what is final and what is not is up in the air in a lot of situations.
Be a middle ground. So if you think about civil procedure, you can have multiple final orders in a case. So for example, you have a partial summary judgment, and although a party could appeal as a matter of right, they can also wait until there's a further final order disposing of all the issues in the case. Could we do something like that in this context? And if not, why not?
The state would not object. I cannot say that I am familiar enough off the top of my head with the rules of civil procedure as to how that works and whether or not that's a rule-specific comes from rule-specific language that we don't have here, whether that's something that could be done here. But as a policy matter, I do think that that would be possible. But I do think that we do need to remember that it's not just the legal question that needs to get resolved quickly, but it's in the best interest of the children to have that issue resolved. This case is a prime example of such delays. As was pointed out here, I think the motion to transfer was filed in January in the China case, and then in February in the TPR case, once the tribe got notice of that the TPR had been filed. And then, as was stated 8 months later, in September, there was a ruling on the motion to transfer. It was another 5 months till we got till we had a termination hearing and a ruling on the termination, and we now stand here 10 months after that. So
These were darn good. There, I looked at the timeline. I mean, Judge Witt, who was a rock star juvenile judge, his funeral was on the day of the first hearing. And then the next hearing date, I believe there was something like, that's when COVID hit. We had that big thing. Had lots of supervisory orders. And then it was it was set within a month of the supervisory order. So I think it was a reasonable period of time considering those really bizarre points. What I want to ask is, I think Father's attorney was hitting on this. Aren't we going to send a message to tribes? You just need to just plain take every case immediately because you're going to lose it if you let them have their hands on it for a little while. Tell me what the tribe did wrong.
I'm not sure the tribe did anything wrong. I want to be clear that the state here is not taking a position on the substantive question of transfer. I think that the state would say that the tribe and the father should have appealed at the time that the transfer was denied in September and resolved that issue as quickly as possible, because if we're going to change venues, if we're going to change attorneys, if we're going to change service providers, that's in the best interest of the children to do that sooner rather than later.
Best interest, sometimes we're talking about, sometimes we're not, but it's a jurisdictional issue. Isn't it also best interest of the child to be in the tribe if that is the appropriate decision? I mean, that has to be weighed as well.
That would weigh towards taking the transfer question earlier. The longer we wait, if you are going to transfer, you want the answer to that now and not later.
Law more protective than the federal law on this question of timing?
I'm sorry, on the question of timing or on the question of what you consider when you're transferring?
Iowa, if you will, does not have some of the language that the federal statute or federal regs actually have with respect to the stages of the proceedings.
Correct. Assuming I can answer, I'm out of time. I think it is. I think that JL says that the state statute violates due process. The state is not asking for JL to be overruled. We accept JL as established precedent in this area. And so in that way, I think that if you just look at the statute, you're correct. But once JL comes into play, then we revert back to the fact that that federal ICWA sets a floor and the state can't go below that. So I believe that the federal rules are binding on Iowa, assuming JL is good law. And so we're asking that question.
We have another question here.
I have a practical question for you. You've mentioned a couple times about how it would be preferable to resolve the transfer issue sooner rather than later. As a practical matter, when it's transferred, let's say later in the proceedings, is there really much time that's lost, assuming kind of the files and everything is transferred to the tribal court? Can't they just begin their process at a much later stage in their own proceedings? It's not as if they have to restart everything at day one. So are we really losing that much time in terms of final disposition?
In tribal court, but that would be my assumption too, that they can start sort of where you left off. I also believe, as was pointed out earlier, that there is this distinction. I mean, the state takes this position on many different issues, but that the China case and the TPR case are not one proceeding, they are two. And I think that that is true in ICWA context too, as played out here by the fact that there was actually two motions to transfer. In January, there was a motion to transfer to China immediately following permanency. That certainly would be late in that proceeding. The motion to transfer in the TPR was filed basically, I think, if you look at the record, pretty much as soon as the tribe received notice of the TPR proceeding. Thank you very much.
My understanding, either Mr. Causey or Ms. Zendeias will be sharing the time, or is just one of you?
She was going to go first, Chief Justice, and then I was going to go second.
Okay. Yeah, good luck with 5-minute split. Usually the first lawyer wins.
I wanted to touch on the what the guardian ad litem had said about the tribe not being involved. The burden for active efforts which is what the guardian ad litem was touching on, is on the state, not on the tribe. The tribe's role in this case is to ensure that the Indian Child Welfare Act is compliant, that the state is in compliance with the Indian Child Welfare Act. And I think that in this case, that burden is being shifted to the tribe, and that burden, according to federal and state statute, is still with the state, and the state did not communicate well with the tribe as far as how they wanted us to work with the Department of Health and Human Services. And another thing is that the guardian ad litem touched on the tribe's connection with the child. That is another impermissible factor. The purpose of the Indian Child Welfare Act, and Congress knew this when they wrote the Indian Child Welfare Act, that there was little connection between Indian children in state court systems and the tribes. And that was the Indian Child Welfare Act's purpose, is to bridge that gap. And so therefore, I don't believe that no connection should be a factor in determining tribes' involvement here. And with that, I defer time to Mr. Causey.
I believe there was a question, I want to give credit, I think it was Justice McDonald, that was asking about sort of this idea of why ICWA was written, I guess, on the federal level, and then does Iowa protect the tribes and the tribal children at even a higher level. I just want to state that the U.S. Congress declared ICWA was to protect the best interest of Indian children and to promote the stability and security of Indian tribes and families by establishing the minimum federal standards. Iowa Code Section 232B.2 also states that Indian tribes have a continuing and compelling government interest in an Indian child, whether or not that child is in the physical or legal custody of an Indian parent. I said this earlier. I think these laws are clear that they are tribal-centric. That is why we have active efforts to keep the Indian family together, to do everything we can above these reasonable efforts to make certain that these children remain connected to the tribe. And again, this is what Ms. Zendeias was touching on, this idea that it is impermissible to say that the tribe didn't do anything or know anything about these children. Dr. Mitchell, our qualified ICWA expert, testified how this isn't just severance of the parental rights from their children between these parents and those children. What it really dealt with is a severance of their entire Indian identification. For instance, my client's middle name is Eagle. It means that he's part of the Eagle clan. And he is going to lose that connection. And there is something about the afterlife where that if these children are no longer part of that Eagle clan, that they won't be a part of the Indian life. And I think this is important because it's just not our position to make that decision for them. I don't have anything else to say. Thank you.
The case of In the Interest of T.F. is hereby submitted. We will now be ready or get ready for the case of In the Interest of Z.K.